Hello, everyone. Welcome to the Low Speeds live class. We're going to go ahead and get started. I'm going to mute everyone. All right, here we go. Let's start off with some common words. Here we go. Copy, love, next, use, here, being, every, night, back, soon, however, because, until, price, better, today, believe, such, course, present, think, old, feel, information, best, note, amount, check, yet, many, never, put, great, possible, cannot, man. All right, now I've got some consonant compounds and they're strictly words. They're not in sentences. We're going to start with initial KR, KL, initial SH, SL, initial GL, GR, and initial PL, PR. Here we go. Cry, clear. Crow, clip. Crab, clock. Crude, club. Crane, clog. Crib, class. Creek, clown. Cream, clerk. Cram, close. Cross, clean. Crowd, clap. Shut, slow. Shade, sleep. Sheet, slab. Shoe, slight. Shack, sled. Shed, slip. Shave, sleet. Ship, slum. Shine, slope. Share, slat. Shock, slide. Glow, grass. Glue, grope. Glide, grub. Glee, grid. Glob, greet. Glass, grow. Gloom, grace. Glad, greed. Glove, grin. Glaze, gross. Glen, grail. Glade, green. Plate, pray. Plus, press. Plight, prune. Plug, price. Plod, prove. Pride, plead. Play, probe. Plow, prick. Ply, prize. Place, prim. Ploy, prep. Plush, prime. All right, now I've got consonant compounds that are in sentences, and this emphasizes on initial SM, initial SPR, final FRS, final NDS. Here we go. The small boy smelled the smoke. Her smock was smudged. She smiled and smirked at the boy. Cal sprained his ankle on the sprinkler. We spread the sprigs to dry. He sprayed the spruce with water. The wafers come in several flavors. Lee prefers or favors one person. She often refers to the handmade covers and sheets that her mother gave her. On Sundays, he delivers the divers to the shore. The quivers were found in the rivers. Sometimes he offers to fill the coffers. Meg attends all the battle of the band's concerts. Bonds are included as part of the funds. The winds blew down the stands. Kyle grinds the rinds. He lends his time and tends to the baby. Lisa finds and sends the data to the East Coast. All right. These are going to be some short phrases and sentences. Here we go. It's only me, just the same. Take a little over the river after the game. Think before you act. Live and play. Try your best. Any old time. Study and learn. Mom means it. The good American. A little boy. Back off. We want to go. Turn the page. A small house. It's still here. Set it up. I study in school. I don't feel well. Point it out. Read the sentence. Big and small. Such a big house. Show and tell. They went here. Good and plenty. Even the animals. I think so. All right. I'm going to give you types of doctors. We've started this, but we have not finished the whole thing. So we are going to complete this today. Excuse me, I have allergies today. All right, here we go. Emergency medicine physician. Endocrinologist. Family practice physician. General practice physician. General surgeon. Genetics specialist physician. Geriatric medicine physician. Gynecologist. Hand surgeon. Head and neck surgeon. Hematologist. Hematologist, oncologist. Hepatologist. Infectious disease physician. Internal medicine physician. Interventional pain management physician. Interventional radiologist. Medical oncologist. Nephrologist. Neurologist. Neuropsychiatrist. Neuroradiologist. Neurosurgeon. Now we do have one side left of this. I'm going to stop here and we will finish this tomorrow. Okay, I don't want to overwhelm you with too many of those. All right. Now I'm going to give you some briefs. I'm going to read the briefs off and then I'm going to go back and read the sentences. If you have any questions about these, if you don't know them, you can always email me. They're pretty basic. Most of them are ones that you learn in theory, if not right out of theory. So if you have any questions, just let me know. Okay. And I'm going to give you some of the ones that maybe I think that maybe you haven't received yet. Okay. So we've got mourn, M-O-U-R-N. And the reason why they give you mourn is because we've got more than. More than is M-long-O-R-N. Mourn as in the early morning, mourn as M-O-R-N. So then mourn, to mourn for the loss of someone, would be M-O-U-R-N. Okay, newspaper, N-long-U-P or N-U-P, either one works. On or about, O-E-R-B. Other than is A-O-N. I don't know, Y-O-N. Pressure, either P-R final R-B or P-R-E-R-B. Just don't get it mixed up with appreciate, which is P-R long E-S-H. Promise, P-R-O-M-S, like a squeeze. Prosecute, initial P-R. Prosecution, initial P-R final G-S. Prosecutor, initial P-R final R. Telephone, T-E-F-L. Treatment, T-R-A-E-M-T. Or you can use the long E, either one works. Will you please, L-U-P. Would you please, W-O-U-P. Yes or no, Y-E-R-N. Are you able, R-U-B-L. R-U-B-L. Rubble would just be flagged. Associate or associate, S-long-O-S-H-T. Association, S-long-O-R-B-G-S. Got the shun in there. Black and blue, B-L-A-B. Of course, you would flag blab if you ever have that word. Brother-in-law. Excuse me. Brother-in-law, B-R-O-N-L. So we use our brief for brother, B-R-O, and then you just add the N-L for in-law. Burden of proof. You can either write that as burp and then flag burp, or you can leave out the U and just write it as initial B, final RP. Daughter-in-law, D-A-U-R-N-L. Defendant's exhibit, D-E-X. Diagram, D-R-A-M. Do you recognize, D-O-U-R-Z. Employ, P-L-O-I, ploy. Employee, P-L-O-I, come back for long E or the A-E, either one works. Employer, P-L-O-I-R. Employment, P-L-O-I-M-T. Enable, N-long-A-B-L, nable. Father-in-law, F-A-U-R, final N-L. So use your brief for father and add the N-L. Now, we've got the I didn'ts in this one. I didn't believe, Y-I-B-L. I didn't do, Y-I-D. I didn't feel, Y-I-F-L. I didn't get, Y-I-G-T. I didn't go, Y-I-G. I didn't know, Y-I-N. I didn't mean, Y-I-M. I didn't say, Y-I-S. I didn't see, Y-I-Z. I didn't understand, Y-I-N-D-Z. And then we have in and out, N-O-U-T. All right, here are your sentences. I like music more than art. All his friends came to mourn him. The newspaper was wet. The incident was on or about the 5th. Other than that, I don't know. To relieve pressure, you must calm down. I promise I won't go. We are going to prosecute. They all came to witness the prosecution. He left his job as prosecutor. I need to make a telephone call. This is inhumane treatment. Will you please shut up? Would you please go away? Do you like him? Yes or no? Are you able to walk? Jack is my associate. We work in association with Mac. I saw black and blue marks. Mike is her brother-in-law. We need the burden of proof. I have one daughter-in-law. May I enter? Defendant's Exhibit 5. The diagram shows he hit her. Excuse me. Do you recognize anyone in here? I will employ that idea. I was an employee of that firm. I do not like my employer. Joe was seeking employment there. This will enable you to talk and walk. This will be your future father-in-law. I didn't believe him either. I didn't do the dishes. I didn't feel it was true. I didn't get any gifts. I didn't go because I was tired. I didn't know you worked there. I didn't mean to offend you. I didn't say that. I didn't see that dog. I didn't understand the question. This is the in and out of the case. All right. I'm going to give you an extension of the words that all start with EX. We started this last week. All right, here we go. Exotic, extraneous, exhort, expectant, expectorate, experience, expect, expenditure, exploit, expire, expedition, expunge, extreme, extension, external, extinction, expropriate, exorbitant, expansion, ex parte, expansive, extemporize, expendable, explode, exponent, expurgate, extent, exuberant, exorcism, experiment, explore, expiate, exquisite, extra, exude, expend, exobiology, expensive, explain, explanation, expose, extend, extract, extravagant, expanded, expel, expert, expropriate, expedite, explicit, expound, exterior, extent, external. All right. Let's do some names and addresses. Here we go. Ready? Barbara J. Kuchler. Kuchler. 4931 Hercules Avenue, El Paso, Texas, 79804. Keith E. Coy, Coy, 7510 Wellington Road, Gainesville, Virginia, 22065. Karen A. Simon, Simon, 4250 Hyde Park Circle, Dayton, New York, 12538. Stephen B. Mock, Mauck, 11 Hawthorne Parkway, Vernon Hills, Illinois, 60061. Annette R. Rebo, Rebo, 295 Turnpike Road, Westboro, Massachusetts, 01581. Andy N. Morales, Morales, 701 North Brand Boulevard, Glendale, California, 92103. Clarissa L. Ashley, Ashley, 5029 Southeast Date Street, Apartment 3, College Place, Washington, 99324. Lee S. Miller, Miller, United National Bank, P.O. Box 1348, 9th and Phillips Street, Penn Falls, South Dakota, 57101. Miss Pamela P. Overton, Overton, Energy Tech Division, 1 Space Park, Redondo Beach, California, 90278. All right. Let's move on to some literary. All right. I'm going to give you some legal terms, and then I'm going to read you a paragraph, and they're all focusing on different legal terms. You're going to hear testimony, which is initial T, final M, exhibit, XIBT, opinion, inferences, counsel, KOUN, closing arguments, charge, examine, which is just initial X, indirect, evidence, EFD, document, DOMT, hearsay, HAERS, identification, FIGS, tangible, circumstantial. The brief for circumstance is SIRK, so you just come back for AL. All right, here is your paragraph. You're also going to hear marked for identification, which is MOID. I'm going to read this at 80 words a minute. Here we go. Testimony and exhibits are introduced in a case to prove certain facts. Testimony is given by witnesses and may include opinions, facts, and inferences. Circumstantial evidence is indirect evidence. Documents and tangible items are presented in the court as exhibits. Exhibits that are accepted by the court are marked for identification and may be received in evidence. Hearsay evidence may be permitted in court. At the close of the case, counsel may give closing arguments. The jury charge is given to the jury by the judge. The jury must then examine and weigh the evidence that was presented in the case. All right, so I did start off at 60 with that one, and I moved to 80, okay? All right. Now I'm going to give you some congressional record, and the subject is political activity. You're going to hear air traffic controller, Percy Act, compromise, integrity, prohibits, concurrently, solicitations, unauthorized, coercion, harassment, quasi-public, political, patrolling, suspension, discretion, implementation, and differentiates. All right, here we go. I'm going to start at 60, and I will work my way to 100. Okay, here we go. Mr. President, I recently introduced SB 134, the Air Traffic Controllers Activities Act, which reforms the Percy Act by permitting air traffic controllers to participate on a voluntary basis in any political activity as long as such activities do not in any way compromise the service or integrity of the air traffic controllers. This bill concurrently protects the general public against unauthorized and improper solicitations, coercion, and undue harassment. Senate Bill 134 differentiates between voluntary and involuntary political activities. It protects the interest of the public while providing air traffic controllers with greater freedom to participate in our political process. The bill provides the following. First, it prohibits the use of official authority, undue influence, or coercion in respect to the right to vote. Second, it prohibits any type of political solicitations by air traffic controllers in government rooms or buildings. Third, it prohibits any type of political activity while on duty, whether inside or outside a government facility. Fourth, it provides employers who are seeking elective office to do so on their own time. Fifth, it designates a special committee, the National Political Protection Board, as the patrolling authority. Sixth, it subjects any person who violates the law to suspension or dismissal at the discretion of the National Political Protection Board. Seventh, it requires the agency of air traffic controllers to make an annual report to Congress on the implementation of this act. Because of the unique position of the air traffic controllers, they are in a quasi-public situation. Most work in a privately owned or state-owned airport where the air traffic controllers are the only government employees. Their role is somewhat independent of most government employees, which means the passage of SB 134 is critical as far as determining their status in political activities. All right, let's move into jury charge. The subject here is responsibility of railroads. Okay, so you're going to hear ladies and gentlemen, which is L long AJ, railway, trains, intersection, NERCs, reasonable, you can write that as RAENL. Reasonably, you just come back for the long E. Engineer, whistle, defendant, DEFT. You're going to hear Smith Railway Company. Substantial, STANL. Plaintiff, PLF. You're going to hear Paul Hopkins. On the other hand, which is long OND, OEND. All right. You're going to hear negligence, NEJS. All right, here we go. Ready? I'm going to start at 60. I'll work my way to 100. Ladies and gentlemen, every engineer driving an engine on any railway is required to sound the whistle at least 80 rods from any crossing with a road or street on the same level, and to continue the sounding of such whistle at intervals until the train shall have completely crossed such road. The fact that the train was not running on scheduled time is of no consequence, and no claim of negligence in that respect is claimed by the plaintiff. The same is true as to the crossing signs at the intersection. The driver of the car, Paul Hopkins, was familiar with the crossing and knew that trains ran daily over this crossing. I think it must be concluded that the plaintiff was negligent as a matter of law. Where a train is proceeding at a reasonable rate of speed, it has the right of way over automobiles approaching and crossing such track, and the engineer on a train has the right to assume until contrary becomes apparent that an automobile approaching the crossing will yield to the approaching train. With regard to speed of trains at crossings, ordinarily the question is one of fact for the jury. A high rate of speed may be perfectly proper at country crossings, but it depends usually upon the circumstances of each particular case. Where a crossing is usually dangerous because of obstructed view, a curve in the track, or a peculiar situation or condition, then a greater precaution is required than would be required at an ordinary crossing where the view is open and unobstructed. You jurors have seen this crossing, and therefore you will better understand the testimony given you in court with respect to the nature of this crossing, and whether or not greater precaution was required than at the ordinary open country crossing, and whether or not the speed of the train at the time of this accident was reasonable under the circumstances. It was the duty of the engineer to sound the whistle for the crossing, and also to operate the train at a reasonable speed under the circumstances. Failure to do that would constitute negligence on the part of the defendant. If the jury finds that the engineer did sound the whistle for the crossing, then the jury will find that the defendant, Smith Railway Company, was not negligent and bring in a verdict for the defendant of no cause of action. On the other hand, if the engineer did not sound the whistle as required by law for the crossing here in question, or did not operate the train at a reasonable speed, then you will take up and consider whether or not such negligence on the part of the defendant was a proximate cause of the accident. If you find from the evidence that the defendant, Smith Railway Company, was negligent in the manner claimed by the plaintiff, and you further find that such negligence was a proximate cause of the accident, then it becomes your duty to bring in a verdict in favor of the plaintiff, even though you find that the accident was caused by the combined negligence of the engineer and the driver of the car, Paul Hopkins. The negligence of the driver of the car does not relieve the Smith Railway Company from liability if the negligence of the engineer contributed to proximately cause the accident. If the accident was caused by the sole negligence of Mr. Hopkins in the operation of the car, then there is no liability on the part of the defendant, Smith Railway Company. But if the accident was caused by the combined negligence of the driver of the car and the negligence of the engineer on the train in failing to sound the whistle for the crossing, or in failing to operate the train at a reasonable speed, and the negligence of each was a substantial factor in proximately causing the accident, then you will find a verdict in favor of the plaintiff and against the defendant. The burden of proof rests upon the plaintiff to prove by the preponderance of the evidence that the defendant, Smith Railway Company, was negligent as claimed by the plaintiff, and that its negligence was a substantial factor in proximately contributing to cause the accident. If, on this question, you find from the evidence that the defendant was negligent as claimed by the plaintiff, and that the negligence of the defendant substantially contributed to proximately cause the accident, then you will find a verdict for the plaintiff for all of the injuries and damages sustained by him. But if, on this question of defendant's negligence, you find the evidence evenly balanced or preponderating in defendant's favor, then the plaintiff cannot recover. If you so find, then your verdict will be in favor of the defendant. No cause of action. To briefly sum up the issues, if the accident was caused by the combined negligence of the driver of the car and the Smith Railway Company, then your verdict will be for the plaintiff and against the defendant for the full amount of the damages sustained. But if you find that the defendant was not negligent and that the accident was caused by the sole negligence of the driver of the car, then your verdict will be for the defendant. No cause of action. If you find that the plaintiff is entitled to recover, then the last question for you to decide is the question of damages. All right. So I got up to 100. Okay. We'll go ahead and start some Q&A. I'm going to start at 60. I will work my way to 100. Okay. All right. Here we go. And it looks like plaintiff is questioning. Here we go. All right. In the event that the possibility that Lauren and Evan are released to you, and if upon their release, if in fact you had the same type of problems with the mother that you previously had, what would you do different, if anything? I would take up more time with Lisa now, and things would be done a lot different. You know, I would have more patience with Lisa because I already know that she were young, but at the time, I feel like I made a mistake. I'm not only faulting Lisa. I made a mistake of giving those kids up too soon. And that won't happen no more. And I get along with Lisa. I can get along with Lisa. That's not no problem. However, if in the event that you could not get along with Lisa, would you ask the social worker for assistance in making different arrangements for visitation? Yes, I would. No further questions. I'm sorry. Just a few more. Okay. When you would ask the social worker to come and get the children, after they had been living with you, do you remember also telling the social worker that you had not followed up with several of Lauren's asthma appointments? I don't remember telling her that because I kept every appointment that I had. I'm not talking about shot appointments now. No, you talking about the asthma, right? Yes. I don't remember telling her that. I might have, but I don't remember missing any of the appointments. Okay, nothing further. Counsel, since you have been having the overnight visits, do you normally pick the kids up, or do the foster parents bring them to you? No, the foster parents bring them to me. Every time? Every time. Do you have any difficulty as far as transportation? No, I don't. So they've been pretty cooperative as far as bringing the kids to you? Yes, they have. And do you understand that the children are to be in regular individual counseling, right? Yes. Would you have any problem in making sure that they get to their counseling appointments, which may be every week? No, I don't. And you say that your relationship with the mother is better now, but you really haven't had much contact with her since the children were moved from your home, right? No. That's no, you haven't? I haven't had contact until I started coming here to court. So you don't know whether her attitude has changed or not? It's changed a lot. She have changed a lot. How do you know that? From talking to her. How many times have you talked to her recently? Every time I come here, we go to lunch, we talk, and I takes her and drop her off. I don't know where she live, but I've been dropping her off, you know, wherever she wanted to be dropped off. That's where I drop her off. And how many times have you seen her recently, would you say? Just here? Yeah. How many times is that? I guess it's been about 4. 4 times? Uh-huh. Yes. I have nothing further. Redirect? Do you know for how long a time you see her? It's been just about all day here in court. And so in those 4 times, you've been able to come to the opinion that her attitude has changed? She's changed, yeah. And during the time that you've been with her, have you discussed the possibilities of your testifying in court? No, you never discussed that with her at all? No. She hasn't told you what she'd like for you to say on her behalf? Oh no, Have you discussed your testimony with your son? No. Have you discussed your testimony with anyone? No. I have nothing further. Counsel, in the event that the children were returned to their mother, are you available to provide daycare for the mother if she goes to work or school? Yes. And if anything came to your attention that you believe that the children were not being well cared for by the mother, would you be willing to report that to the social worker? Yes, I will. No further questions. Counsel, Mr. Jandra? No questions, Your Honor. Counsel? Yes, I'm sorry. At the time that Lauren and Evan were placed in your care, were you told by the social worker to take them in to the doctor for Medi-Cal shots and treatments? No, I've done all that on my own. No further questions. Counsel, would you have any reason to not believe the children if they again said to you that their mom had done something to them? Can you say that again, please? Let's say the children were returned to their mother and they brought to your attention that she hit or something went wrong had happened. Do you think that you would be able to believe them? I would check into it. I wouldn't just shine it on, you know. But you didn't check into it when the previous statements were made, right? No, I didn't. Asked and answered, Your Honor. I have nothing further. Counsel, nothing. I have nothing. Okay. Ms. Smith, thank you very kindly for answering these questions. You are now excused as a witness. We will take a recess at this time. All right. Let's go ahead and do some read back. All right, so this is going to be defense questioning. This is a continuation from the read back that we started last week. You're going to hear alleged, victim, complaining witness, closet, cluster, doorway, identify, F long I, Mark Vincent, Mr. Thomas, gentleman, detain, effort, station. All right. So again, this is going to be defense questioning, and we're going to start. The first take will be at 100, then we're going to go to 80 and then 60. Here we go. Ready? And the alleged victim, the complaining witness, was in a closet area just to the right. Now, I would like to know how many persons were in the one room that you saw. I would have to be guessing without looking at the report. I'd have to guess that there were probably 11 in the room. Were they all in one cluster, as you said? That's correct. They were within 15 to 20 feet of the doorway. Are you able to identify any of those persons that were in that group? Yes. And was Mark Vincent, the gentleman there, in the room? I can't identify him for sure. And Mr. Thomas, was he in the room? Yes, he was. Where was he in the room? Within 15 or 20 feet of the doorway. And I believe that Mr. Thomas was just off to the left. What time did this man come to the station? Shortly before 7 p.m. How long was he in the station? Maybe 2 to 3 minutes at the most. Did you talk to him? Yes, I did. Is there any reason why you didn't have him stay or detain him to find out who he was? He had stated that he didn't want to and that he was afraid. There were a few things along that line. So you just let him go? That's correct. You made no attempt or effort to find out who he was or follow him or have someone follow him? No. Have you seen him since that time? No, I have not. Had you ever seen him before that time? No, I had not. All right, let's do it again at 80. Here we go. And the alleged victim, the complaining witness, was in a closet area just to the right. Now, I would like to know how many persons were in the one room that you saw. I would have to be guessing without looking at the report. I'd have to guess that there were probably 11 in the room. Were they all in one cluster, as you said? That's correct. They were within 15 to 20 feet of the doorway. Are you able to identify any of those persons that were in that group? Yes. And was Mark Vincent, the gentleman there, in the room? I can identify him for sure. And Mr. Thomas, was he in the room? Yes, he was. Where was he in the room? Within 15 or 20 feet of the doorway. And I believe that Mr. Thomas was just off to the left. What time did this man come to the station? Shortly before 7 p.m. How long was he in the station? Maybe 2 to 3 minutes at the most. Did you talk to him? Yes, I did. Is there any reason why you didn't have him stay or detain him to find out who he was? He had stated that he didn't want to and that he was afraid. There were a few things along that line. So you just let him go? That's correct. You made no attempt or effort to find out who he was or follow him or have someone follow him? No. Have you seen him since that time? No, I have not. Had you ever seen him before that time? No, I had not. All right, let's do it one last time at 60. Here we go. And the alleged victim, the complaining witness, was in a closet area just to the right. Now, I would like to know how many persons were in the one room that you saw. I would have to be guessing without looking at the report. I'd have to guess that there were probably 11 in the room. Were they all in one cluster, as you said? That's correct. They were within 15 to 20 feet of the doorway. Are you able to identify any of those persons that were in that group? Yes. And was Mark Vincent, the gentleman there, in the room? I can't identify him for sure. And Mr. Thomas, was he in the room? Yes, he was? Where was he in the room? Within 15 or 20 feet of the doorway. And I believe that Mr. Thomas was just off to the left. What time did this man come to the station? Shortly before 7 p.m. How long was he in the station? Maybe 2 to 3 minutes at the most. Did you talk to him? Yes, I did. Is there any reason why you didn't have him stay or detain him to find out who he was? He had stated that he didn't want to and that he was afraid. There were a few things along that line. So you just let him go? That's correct. You made no attempt or effort to find out who he was, or follow him, or have someone follow him? No. Have you seen him since that time? No, I have not. Had you ever seen him before that time? No, I had not. All right, so all 3 takes are exactly the same. So since we don't have any live students or students in the live class, I don't really need to go back and do the read back. All you have to do is choose which take you want, go back to that, and then listen to it and compare it to your notes. They're all 3 the same. So if you want to go to the 60 take, you can, just so that it's slower and you could follow along a little bit easier, and compare it to your notes and see how you do. All right, so that concludes our Lower Speeds Live class. Have a wonderful day.